A very warm welcome to the seventh lesson in our series on the law of evidence. In today's video, we will talk about facts. I will not be talking about facts strictly in terms of the law of evidence. Instead, we will try to understand the concept whereby a fact is distinguished from the law. So we will be seeing questions of fact, questions of law, and mixed questions of fact and law. Let's go into the lesson. Fact has been defined in the Indian Evidence Act in Section 3. So Section 3 of the Indian Evidence Act contains the interpretation clause that gives you several definitions. But this is not what we will be doing here today. I just want to tell you a little bit about facts instead. So here's what we need to know about facts. Okay, when I say that it's a fact, then many of us think of this as being synonymous to saying that it is the truth. So generally, we say that it is the fact, as if to imply that it is the truth. But this is one very important point that I want you to take note of. It is not necessary that the fact should be the truth. A fact is basically something which could be true or false. So in the context of the law, the fact does not imply truth or falsehood. It just is a fact, okay? And a fact could be either true or false. Then on the basis of evidence, the court decides whether the fact is true or not, right? So the only point that I want you to know is that a fact does not imply the truth. A fact could be either true or it could be false. Apart from that, for details on what a fact is in the scheme of the Indian Evidence Act, you can click on the I button here and watch this video by clicking on the I button at the top right of the screen. Now we come to the topic of today's discussion. What is a question of fact and what is a question of law? You see, a question of fact is a question, the answer to which is a fact, which means let us say something is a question of fact. It means that the answer to this is a fact. Okay. Similarly, what is a question of law? A question of law is a question, the answer to which, so the answer to this question of law would be the law. Perhaps you have not understood. Let me give you a few examples to understand this a little better. Let us say A is accused of the murder of B. Okay. So let us see what we might have as a question of fact. Where did A stab B? Did he stab him on the chest or did he stab him on the hand? So you see, this is a vital part, this is a non-vital part. Or did he stab him on the throat? Or did he perhaps stab him on his legs? Again, where he stabbed him is important, but it's a question of fact, because what are you going to say in response to this? You will say, either you will say hand, or you will say foot, or you say chest. Whatever you say, the answer is a fact. You don't need to look at the law. You simply speak of a fact that, okay, he hit him here, he hit him there. Similarly, how many times did he stab B? Maybe he stabbed him 5 times, maybe he stabbed him once, maybe he stabbed him 4 times. Again, you don't need to look at the law to answer this question. Therefore, these are questions of fact. You see, these help determine as to what the offense would be. Because let's say if somebody stabbed someone else 100 times, then that makes it a graver offense. But the question is one of fact and not of law, because the answer is a fact. So whenever the answer to a question is a fact, it means that question is a question of fact. So the answer to these are facts. Therefore, I can say that these two are questions of fact. On the other hand, when we look at questions of law for the same case, then whether he is guilty of murder or whether he is guilty of culpable homicide not amounting to murder, for this you need to refer to the law. For example, if it is murder or culpable homicide, you will need to look at sections 299 and sections 300, because if you don't look at these, then you can't know as to whether the offense committed was culpable homicide or murder. So you see, the answer to this question lies in the law. You have to refer to the law in order to be able to answer this question. However, in order to answer these questions, you don't need to look at the law. You just look at the facts of the case, right? Let me give you another example. Again, the same case where we have A accused of the murder of B. What is the age of A? A's age may be 65. A's age may be 75. It could be 95. It could be 5. It could be 5 months. You see, there is a significance of the age. Let us say B was a man of 25 years of age, okay? And he was a tough, well-built guy, and he was trained in martial arts. Let's say this guy was a trained guy in martial arts, okay? Now, if we say that A was 95, now at 95, is A strong enough to stab B to death? Well, it's an important question. So age is important as far as the decision is concerned. But that's not what we're looking at. The point is, if you're asked the question, what is the age of A? Do you have to look at the law to answer this, or do you have to look at the facts? You look at his birth certificate, you look at his school leaving certificate, or something, his Aadhaar card or whatever, and then you understand the fact of his age. Similarly, let us take this age 5. Perhaps you are aware that when a person is below the age of 5, actually below the age of 7, then according to section 82 of the IPC, he is not guilty of any offense. So again, you see, the age matters a lot. But again, it influences the decision. But is it a question of fact or a question of law? Are you looking at the law? No. You are looking at what? His birth certificate, his school certificate, perhaps his driving license or whatever. So you understand that what is the age is a question of fact, because the answer to this is a fact. In order to answer this, you don't have to look at the law, you simply look at facts. However, if I were to ask you a slightly different question, and the question is A entitled to the defense of infancy? The defense of infancy, like I said, is what we understand as the Dolly in Capax, yeah, which you find in sections 82 and 83 of the IPC, which are basically the defenses for offenders who are young, so under the age of 7 or under the age of 12 years, right? So now, to understand and to know whether a certain person is entitled to this defense, to this general exception, where do you see? You look at the law. If there were no section 82 and 83, you could not have answered this, right? So the answer to this question lies in the law. Therefore, this one is a question of law and not a question of fact. I hope you've understood the point. Ask a question, then look for the answer. If you find the answer in the facts, it's a question of fact. If you have to look at the law to answer that question, that is a question of law. You might be wondering as to why I'm talking about this right now. It is important even in the context of evidence law. You see, as far as presumptions of fact and presumptions of law are concerned, it's important for us to make this distinction. You can click on the I button here and you'd see the video on presumptions of fact and presumptions of law. It would help you immensely to see that. Perhaps you can see it later or you can see it now, as you wish. But to know the distinction between law and fact is very important. Let us take this discussion a little further ahead. So as we know, there can be questions. Questions can be purely questions of fact or purely questions of law, which means that we're talking about a question of law which is pure. It does not have any facts in it. It's purely a question of law. Similarly, we have pure questions of fact. So this is one kind of questions, the kind of questions which are pure. On the other hand, you have mixed questions of fact and law. Perhaps you may have seen this phrase used somewhere. Let me talk a bit about the significance of this now. You see, in life, generally things are not available in their pure form. So for example, even when you have to go and get iron, you find it in the form of iron ore in its raw form, and then iron has to be extracted from it. So generally things are available as a part of a mixture, generally. And the same exists even with questions of fact and questions of law, which means that, let us say, what looks like a question of law to you, okay, primarily, also has this little part which is perhaps a question of fact, okay. Likewise, what looks predominantly like a question of fact must be having a little bit of law in it. Okay? I will talk a little more about this, but I just want you to understand that questions that are very purely questions of fact or questions of law are very rare. But then if something is substantially a question of law, we call it a question of law. Talking about substantial questions of law, you must have, again, substantial questions of law. You must have heard of this phrase as well. And this is a phrase that is very important when we talk of appeals to the Supreme Court. So, in the comment section, I want you to write down the articles, right? The article numbers in the Constitution where you see the usage of this phrase, substantial questions of law. You see, the Supreme Court, being the apex court, does not want to deal with questions of fact. It deals with the interpretation of the law. So it only wants to answer those questions which are questions of law, right? So it only deals with questions, the answer to which lies in the law, because it's the apex court, and the apex court wants to interpret the law and not entangle itself in understanding the factual matrix. That is left for the lower courts to decide, okay? So make sure you look for that in the Constitution of India and write down the article numbers in the comment section. So we do understand that questions of law and questions of fact can sometimes be mixed. Let me show you a few examples of what this composite mixture is. In fact, like I said, it is almost inevitable that questions of law and questions of fact will coexist. You see, because the law in any case, as we've seen, does not deal with irrelevant questions of fact. It only deals with questions of fact which are relevant to the matter at hand, which means there's an element of law in fact, and there's always an element of fact in law, because law is also a fact. I know this is getting very abstract. Let's just look at a few examples. You see, a judicial determination, which means any decision, okay? Any decision requires both the facts and the law to be considered. However, questions of fact and questions of law can be separated, which means the questions of fact and questions of law are separable, okay? You can divide them into pure questions of fact and pure questions of law. Let me cite you an example. Okay, so judicial determinations require both the fact and the law to be considered. Let me show you how. Let us say there's a dispute before the court, okay, and this is what has to be decided, okay? Obviously, the court has to determine whether a certain structure that is constructed in a certain place, is this legal or is this illegal? Now, in order to decide this, it has to answer two questions. The first question is, what is the height of this building? The second thing, what is the maximum height that has been prescribed by the law? So let us say there's a building here, okay, so let's say this is a certain locality, okay, there are many buildings here. This is a road, okay. Now this building is maybe 100 feet, okay. So what is the height of the building? 100 feet. What is the upper limit prescribed by the law? Maybe it is 80 feet. So is the building legally constructed or illegally constructed? Well, you need to look at both these things to decide, correct? But I hope you understand that one of these is a question of fact and one of these is a question of law. Which is the question of fact? The question of fact is the question whose answer is a fact. So the height of this building, just take a rope and a measuring rope and just calculate the height and you get 100 feet. It's a question of fact. But to get the limit prescribed by the law, you have to look at the law. So the answer to the second question lies in the law. You have to look at that particular rule which says that 80 feet is the limit. So, as you can see, this first question here is a question of fact. The second question here is a question of law. And in order to decide this question, the court has to look at both of these. So that's what we saw in the beginning here. that both the fact and the law require to be considered, right? So we've understood that the two questions have to be seen, but these two are separable. That's the point that we saw in the previous, in a little while ago, that these two questions can be separated. It is possible for you to see that what is the height of the building. The first question is a pure question of fact, 100 feet. You can calculate it. The second one, what is the limit prescribed by the law? Well, the answer to that is 80 feet. You find that answer in the law. This answer you find in the facts. So although you used both to decide the answer, the two are separable. You can distinguish the question of fact from the question of law. I hope this has clarified the point as regards question of fact and question of law with you. When we talk about mixed questions of fact and law, they depend on relative standards. Let me give you an idea to explain what I mean to say. You see, in the previous example, when we are considering the height of the building, okay, the height of the building doesn't require comparison. You see, when you ask me what is the height of the building, I don't need to look at another building to determine whether this is 100 feet or 50 feet or 60 feet. I can just go calculate independently and decide, right? However, when we talk of mixed questions of fact and law, like with most things in life, the calculation, the computation, and the standards are relative. For example, if you are to say as to who is, say, the winner of a case, let's say A versus B, you always know that no person is fully correct and no person is fully wrong, right? You're only looking at a relative standard. So when you're calculating and when you have to evaluate whether something was necessary or not, for example, maybe you must have heard that in the quasi contracts, you must have known that the supply of necessaries to a minor, supply of necessaries to a minor, right? So you have this section 68 to 72 in the Indian Contract Act, right? So you see, when you talk of, I'm not talking about law of contract now, I'm just talking about this word called necessaries. Now, what is necessary? Well, it's a very relative term. You can't quantify that. You can't give it a number. So it is a relative term, and most things in life and law are relative. And this is where you realize, therefore, that most questions are actually mixed questions of fact and law. However, you can decide them as being substantially questions of law or substantially questions of fact. I've made my point clear. So we know what a question of law is, what a question of fact is, and that when these things are slightly interlinked, then they become mixed questions of fact and law. I will end by showing you a little example of how fact and law are sometimes very closely intertwined. Let us talk about the tort of negligence. Okay, so you know what negligence is. The tort of negligence basically means that you had a certain duty of care and you failed to take care, and as a result of that breach of care, there is a certain damage that has occurred, which means that you are now guilty or you're now being tried for the tort of negligence. Now, what is negligence is the question. The absence of prudence, they say. So if you're not prudent, it means you are negligent. Okay. Next question. What is prudence? Well, to that you answer that prudence is the absence of negligence. Okay. If that wasn't already getting too unclear, let's look at a few more questions. Who is prudent? And then you say the reasonable man is prudent. Then you ask, who is the reasonable man? The answer you find is that a man who is prudent is the reasonable man. Who is guilty of negligence? Well, someone who was negligent. You see, there is a kind of cyclical thing that is going on here. So the fact of what is prudence, okay? Who is prudent? Is it a question of law or is it a question of fact, right? Who is a reasonable man? Is it a question of fact or a question of law? You see, the law and facts are so closely interconnected in this that you can't really demarcate. And I just wanted to show you this little example for you to know that these are mixed questions of fact and law, right? So we've seen some questions of fact, we've seen some questions of law, and we've learned the concept of mixed questions of fact and law. I hope you found this lesson interesting and that it was of use to you. Thank you for your patience. Good day.